allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Civil roll call, please.
Chairman Weigel.
Here.
Judy Ogawa.
Here.
Ron Howard.
Here.
Steve Ballard.
Here.
Lawrence Daly Perry.
Here.
Okay, we have a quorum. We have minutes from July 12th. We have a motion to approve.
So moved.
Motion, second. Any additions or corrections? All in favor say aye.
Aye.
Any opposed? Motion carries. New business, our first case, Kimberly.
Steve Lazar will be presenting the zoning case today.
Okay.
Thank you, Mr. Chairman and members of the Land Use Development Committee. This is a very interesting case, and I want to start out with just a little bit of history. Real quickly, this case actually transpired because of a violation on the property. The applicant initially requested an opportunity to propose a landscape business on a residential district. As our ordinance clearly defines the purpose of residential districts, that type of use is not allowed. The applicant then petitioned the Planning and Zoning Commission requesting an opportunity to be heard in objection to our zoning administrator's opinion, and the Planning and Zoning Commission granted them an opportunity to be heard. So the case before you today actually went to the Planning and Zoning Commission, I believe, last week, and it is a special use to operate a landscape business on the property, which is currently zoned R2. Variance for accessory structures from 1,800 square feet to 4,000. Variance for the maximum amount of commercial vehicles, and the vehicle weight limit, a variance from 8,000 pounds to 25,000. And again, one of the most important things to remember about this case as we talk about it, I'm going to go through a real quick PowerPoint with you, is that the purpose of the residential zoning district is very specifically defined for residential uses. In trying to put a landscape business on a residential property really defeats the merits of the zoning ordinance and the purpose of the residential district. So I'm going to go through a series of PowerPoint slides and talk briefly, and then we'll summarize the case and give you an opportunity to ask questions. This is an aerial view of the subject property. As you can see on the south end, there's a horseshoe driveway, and that accesses the applicant's primary residence facility. If you look on the right side of the screen, you can see a partially dedicated unimproved road, and that accesses the rear portion of the applicant's property where the landscape business takes place. This road is unimproved. There was some controversy trying to determine whether it was dedicated or not. What we've determined is that it actually was dedicated to the DuPage Township Highway Authority, which no longer exists, so it's dedicated to DuPage Township. It's unimproved, and it's a half right-of-way at this time. And again, that road just accesses the rear portion of the property where the applicant's business takes place. If you look at the surrounding parcels, the majority are zoned residential. This is on Bluff Rd. This is a swath of residential zoning properties. The majority are very well kept homes, some with larger lots, and really the thing that we want to emphasize is that commercial use such as a landscape business would really conflict with some of the uses there, specifically the residential uses. There is commercial directly to the north, however, that is within the village of Woodridge's municipal limits, and that is a planned industrial park, not a landscape business that was thrown in haphazardly amongst residential uses. This is the applicant's site plan, and again, I want to emphasize the majority of the landscape business takes place on the northern portion of the lot. It does show the existing structures. However, there are a few buildings that are not shown. Specifically, there's a picnic pavilion and a couple other incidental structures that are not shown on the site plan. This is the north side of the applicant's property, and you can see the pavilion looking westward towards the commercial uses that exist, and there's a pole barn, and we have a better picture of that in a minute. And then there's kind of a, I almost call it like a greenhouse structure. It's a frame type structure that's used for the landscaping business. Again, the north portion of the property, and as you can see, the pole barn is right there. It's, I believe, kind of beige in color, and it is kind of an anomaly in a residential district, again, where this commercial use is taking place. This is a little further to the north, and this is showing the industrial park in the village of Woodridge. And again, these are planned industrial uses. This was a planned development, and upon staff's inspection, we kind of concur that all of the warehousing, industrial type uses take place in enclosed buildings, not outside. This is the applicant's house on the south of the property. It is accessed by a horseshoe driveway. The applicant's house is very well kept in nature. It matches perfectly with the other residential uses along Bluff Road. This shot is actually looking eastward along Bluff. I know the title says looking south. This is actually a shot looking eastward, and you can see that this is a very nice, very wooded residential area. Again, nice residences, very well kept. Although there are residentially zoned lots, it's almost an estate type setting. This is the property to the south, just across Bluff Road, and at this time it is currently undeveloped. And I want to go over staff's recommendations. Again, we are denying the special use permit for the operation of a landscape business in the residential zoning district, specifically based upon our zoning ordinance, which defines the purpose of the residential district. And in nowhere does it elaborate on landscape businesses or those type of businesses being permitted as of right or considers a special use. We are also denying the 3 variances, and they correspond to the special use permit. Again, we don't feel that this business is appropriate in that area. It's still a very well kept residential area. And then the last thing I want to go over is a couple of the conditions. We had requested the hours of operation be from 8 a.m. to 5 p.m. and that corresponds directly with our home occupations. As you may know, certain home occupations are allowed in residential districts. Those are ones that take place in the house. Something like an accounting firm or something like that could take place in a residential district. This is clearly an opposite of those type of uses. However, we did try to impose the same hours of operation that you would find in a home occupation. And then we also changed one condition towards the end regarding the special use permit. And the special use permit would run with any family members that would continue this business or any family members that would have a direct controlling interest in this business. Again, I want to emphasize staff's recommendation is for denial of the special use permit. It is also a denial for the 3 attached variances. And the rationale behind that is that this landscape business is not in conformance with the area, with the context of the area, specifically residential. And the other thing, again, the applicant was advised at the time of submittal that this was not an appropriate use. And we have a concern that the appeals process was used to circumvent the ordinance as opposed to relying upon our zoning administrator's decision. And really, in doing that, we really kind of circumvent our ordinance and kind of disregard all the purposes and intent that's built into that, not just the appropriate uses. That is staff's findings. Thank you.
Is there any questions by committee members?
Yeah.
Mr. Howard?
Yeah, is the attorney here for us? Oh, I'm sorry.
Is the attorney here, or the owner here, or anybody, or answer questions, or?
Yes.
Yes.
Okay.
You ready for it?
Yeah, I am.
Good morning. My name is Tom Osterberger. I'm one of the attorneys for our petitioner today. Sophia Serrano, one of the owners, and her daughter Maria are here to answer any questions. In response to staff's recommendation, I want to point out a few things. And I don't think we saw an aerial in the area here. We're directly abutting, it's a planned use, commercial use, enormous buildings, okay? So regardless of whether it's planned or not, when we look at zoning, we look at the trend in the area. Most of you guys are familiar with that area. We see large-scale development going on.
It's up there now.
Okay.
There's a better picture here, though.
And when we look larger, I mean, we have, you're familiar with the area, a lot of big boxes in the area. So the petitioner has operated this for 14 years. And yeah, it's been in violation, no doubt about that. I won't go into the history or how that happened, but it has. And so when they came to us, our choice was to come in and ask to have a rezoning, so we have legal issues, go to Woodridge, something they don't want to do, we don't want to do, and so we preferred to try to ask for a special use to continue to operate as they have. We had, at PCC, we had neighbors here in support, nobody objected, and we received the approval at that level. It is a tough area because it's changing so much, but we have a good operator. One of the conditions is they continue only with the family membership or control, so that this goes away, they can't sell it off to somebody else. And we think this is the best use for the area. Again, nobody objected, and maybe somebody's here to object today, but nobody objected, and we had people in support, and they run a great operation. I know it's unusual, but we think this is the best resolution of the matter.
Yeah, thank you for the explanation, because I was concerned if there was somebody that was objecting to this, but when you look at the aerial photography, and I'm actually very familiar with this area, it's a very unique area. I mean, you literally have a house that backs up to a precast million square foot stand-up building there or whatever. And apparently, correct me if I'm wrong, but it sounds like the history is they've been here a while. They actually grew with the community. Okay, they're an agricultural-based business. Basically, they grow things. It looks like it's well kept. They're good neighbors, so I could see where, yes, it doesn't fit our criteria, but at the same time, we have to change. I mean, we have to change with the times too. So, I think this is, as long as nobody's objecting to it. Again, it's nice to live where you actually work. I can see that, and live where your business is. I think the benefits of that. So, I will be in support. I will support the property owner rights in this respect. Thank you.
Steve, you have a comment?
No, Bob did what I wanted to do.
Okay. Any other comments? Are there any objectors to this? Okay. We have a motion then to approve the
Second.
special use permit for operating a landscape business. We have a motion and a second. All in favor say aye.
Aye.
Any opposed? Motion carried.
Thank you.
Thank you.
Do we need to do the variances, Steve?
Actually, Mr. Chairman, the variances were approved at PZC, and I believe the special use permit just travels forward from this committee. So thank you.
Okay, thank you.
Thanks.
Next case is Dollar General Store. Kimberly, you want to give us an update?
Thank you. Zoning case ZC-16-005 takes place in Joliet Township. The applicant requests a special use permit for a planned unit development and a map amendment from R6 to C3 to allow for a Dollar General store to be developed. The case went before the Will County Planning and Zoning Commission on August 2nd. The commission voted unanimously for approval with a 7-0 vote. The general location of the development is east of Illinois Route 53 and south of Zarley Boulevard intersection. This area is part of the 25-mile focus area for the corridor plan for the Illinois Route 53 Historic Route 66. The three goals of this plan were to, 1, create one cohesive plan, 2, create an economic engine for the region, And 3, create a major tourism destination in Illinois. The subject property consists of 2 contiguous parcels. Parcel 1, pin ending in 019, is a 0.27 acre parcel that is improved with 2 asphalt drives and a building that was previously used as a car wash. The car wash is to be demolished. Parcel 2, pin ending in 020, is a vacant 0.58 acre parcel. Displayed before you is a zoning map. The subject property is highlighted in yellow. Parcel 1 is zoned Z3 and parcel 2 is zoned R6. The applicant is requesting a map amendment from C3 to R6 for parcel 2. The parcels will consolidate into a single C3 parcel upon consolidation, or upon approval, pardon me. The property abuts residential properties within the Preston Heights subdivision with R3, R4, R5, and R6 properties. Directly north is a Speedway gas station that is zoned C4 and a used auto sales business west of Illinois 53, zone C4. Directly west is multifamily, zone residential R6. Displayed is a photo of the existing car wash that is to be demolished. The photo displayed is a photo facing north along Illinois 53 and facing south. The subject property is 0.85 acres. Dollar General proposes a 7,225 square foot retail development. The developer is restricted by the lot size. In order to locate this development on the property, a total of 8 potential variances are needed. The applicant proposes a planned unit development to address these variances under a single zoning action. In return, the developer must provide cross-access, a monument sign versus a prototype freestanding sign, a more attractive building, sidewalk and sidewalk connections, a solid wood fence buffer, a landscaping theme, planted containers, and fully shielded outdoor lighting. Cross-access with Speedway to the north is a condition of this zoning case. Cross-access is needed to minimize potential traffic conflicts for vehicles traveling across properties. Without cross-access, vehicles traveling from Dollar General to Speedway will have to navigate across a busy 4-lane highway with a median. The department has made contact with Speedway on behalf of Dollar General, and Speedway does agree to cross-access. However, the final agreement is the responsibility of Dollar General. It is my understanding that Speedway may desire a possible shared parking agreement for 2 potential parking stalls, because they will lose parking to accommodate the cross-access. Dollar General must provide full access and work with Speedway to see this through. In lieu of a prototype freestanding pylon sign, Dollar General proposes a more attractive monument sign with a brick foundation and a more attractive storefront with an increase of brick veneer. The development will service neighborhoods that are within walking distance. A sidewalk is proposed along the portion of the frontage from the driveway to the north. So here in blue is a continuous sidewalk. There's a sidewalk connection at the southwest corner. Due to a low building elevation, a 4-to-1 slope was created for stormwater purposes. The slope does not allow for a continuous sidewalk, so a connection that will allow pedestrians on and off the site is proposed at the southwest corner. By ordinance, commercial uses are required to have one of 3 buffering options when abutting residential use. All require a minimum of 10-foot landscape strip with other features such as a solid fence or a landscape berm. A 6-foot solid wood fence without a landscaping strip will allow an 8-foot clearing between the building and fence to allow emergency access on all sides of the proposed building. The ordinance has a provision to allow for alternative compliance when a landscape requirement cannot be met. In this particular instance, the road frontage landscaping is deficient. This will be addressed under the PUD. In return, Dollar General proposes to use perennials, such as ornamental grasses and native grasses to include featherweed grass and little bluestem to mimic a prairie-like landscaping theme. Planted containers could soften the warehouse storefront with minimal windows. Dollar General proposes outdoor lighting. All sources must be shielded to prevent light and glare spillover to adjacent properties and the budding rights of way. Displayed are the preliminary architectural plans that were provided. And the traffic study. So what you have displayed here is it's traffic information from the ITE Church General Manual. A Dollar General of this size is expected to generate 29 trips in the peak morning hours and 52 in the peak afternoon hours. The total average number of daily trips is estimated at 480. According to the applicant, the anticipated trips show that Dollar General stores are not high traffic generators and by themselves rarely cause the need for geometric or traffic control improvements on roadways adjacent to their site. Displayed is economic information. The store is expected to generate approximately $131,250,000 in total sales, with approximately $11,250 going to Will County. A total of 6 full-time jobs and 2 part-time jobs are expected. The project is expected to begin October 2016 with completion April 2017. A total of 28 vehicle and 3 bicycle parking stalls will be provided with a minimum of 24-foot wide drive aisles. Additional drive aisle width is required at the north portion of the parking area to accommodate truck turn movements and deliveries. Access will be provided via a 35-foot wide full access driveway from Route 53 that aligns with the existing median. Also, 2 ADA parking stalls are also provided. Other comments were received from the Joliet Fire District and the Will South Cook Soil and Water Conservation District. However, no objections were received. Staff supports the request and recommends approval of special use permit for planned unit development and approval of a map amendment from R6 to C3 with the following 5 conditions. And that concludes staff's analysis.
Any comments from committee? Judy?
I think people like Dollar General everywhere. It's nice for the smaller communities where they don't have anything right close to them. I like the fact that Dollar General's kind of stepping it up as far as the requirements you guys have, the landscaping, and added some brick veneer so it looks nicer than a typical store might look. So I think it's good, and I think the residents will enjoy having it in their neighborhood. So thanks.
Yeah, my question is on the cross-access with the fire department. Wouldn't that be beneficial for the fire department to have that cross-access for a fire truck? Because generally they require that they can drive around the entire building, but if there's a problem and they have to go back out onto the street and then enter back in, I mean, it's something that maybe point out for long-term planning, especially if Dollar General or Speedway vacates, we still have that cross-access for the emergency.
Sure, the cross-access is beneficial on many levels. We did receive comment from the fire district. The calculations for the development is tight. It just meets the minimum requirements for the fire district. They did not object, and they did agree that it was adequate. However, they did not comment specifically on the cross-access.
Can I request that we actually just ask for their review of that again with cross-access?
They will review the building permit as their required approval, but also the cross-access is a requirement. It's a condition for the zoning case, so we're
Correct.
requiring.
Okay, good. All right. So we got it covered, so. Okay, good.
Yes.
Thank you.
Any other comments? Any objectors? You have comments?
My colleague, Herb Brooks, and I are both in favor of this development. We want to see that come there very badly. I understand that there may be some issues with the cross-access, not because Dollar General doesn't want it, but because the two corporate entities trying to negotiate that have not come to an agreement yet. What I would like to see is that the cross-access continues to be a part of this process, but that Dollar General is allowed to proceed while they finish the negotiation on the cross-access.
Okay.
Is that a possibility?
David?
You may want to have legal counsel comment on this, but if the PUD is approved by action of the board and includes the provision for the cross-access, what that's saying is this is what the board is agreeing to in lieu of all of those other variances. The applicant could then proceed under the terms and conditions of that PUD. If in their negotiation with the party next door to them does not come to fruition and they believe that therefore they cannot fulfill the cross-access requirement of PUD, there is an established process where they can then come through the board seeking an amendment to the terms and conditions of the adopted PUD. So the short answer to your question, ma'am, is that yes, they could proceed, but if it proved impossible in their view to fulfill that element of the PUD, they could seek an amendment to the terms and conditions of the PUD. So anything that needs to be added on that point? That covering it?
It's the only other hook would be if the condition was removed or if it was changed to actually to reflect final occupancy. It would be somewhat difficult, when you get that far, to withhold occupancy based upon cross-access with the investment that they would have made. So I really don't think holding it at final occupancy is really an option. As far as the way it's adopted as a condition, that's board approval. And typically, we look at major and minor amendments to PUDs, and I'd have to actually look at the verbiage right now to see how this would impact whether or not they call major or minor. But even so, when something's typically a condition of a special use permit or a PUD, and the board has approved it, I don't administratively modify that because that is something that you as elected officials have placed upon that approval as a condition. So I was going to talk with Matt here for a second, look at the language and see if there's any modification that could be made to reflect how this would proceed for amendment if they can't come to terms.
Thank you. The person I'm signaling is the representative from Dollar General. And as I said, I do want to see it there, and I believe the cross-access is needed. I believe it's required in that area. I'm just wondering if there should be a snag in the negotiations. Is there another way that we can mitigate the traffic issue there?
Thank you very much.
State your name, please.
My name is Brandon Lott. I work with Farnsworth Group. I'm an engineer out of Peoria, Illinois. Matt Shoemaker was the applicant. He's no longer with our firm, so I'm representing him and I'm an engineer, not an attorney. So thank you. I wanted to make a quick comment that might help understand some of this, update you on where these negotiations are at, and then make a request. First off, I think it was presented very well. This is a good development, bringing jobs and services to the neighborhood. Into a growing corridor, I think in line with what is anticipated. We really appreciated working with the staff, looking at, there were 8 conditions up there, or 8 pieces of the PUD. 7 of those 8, including the landscaping, the facade, sidewalk, signage, all these things, happy to accommodate, to be a good neighbor to fit into the corridor. Safety is important, and I know that's been a comment, and what we've done, can you go to the second slide? Right now, there are 4 entrances between 2 streets that border these properties. Between Zarley and, I don't know the name of the one to the left there. To the left, Ottawa, Chicago, the one that goes east-west. Between the 2, but you can see there are 4 entrances from north to south, 2 into Speedway and 2 into the car wash at this point in time. We recognize that's an unsafe condition, and the proposed development eliminates 2 of those entrances and lines it up with a single entrance that lines up with the east-west, so that what you're doing is eliminating and aligning the entrances. 1, 2, 3, 4. These 2 are eliminated, and 1 single entrance is here aligning with this street. So to eliminate these 2 of course would remain. That's on Speedway's property. This is important, and it's important to also note that we're working with IDOT. It's been submitted, and whatever comments they may have is something we're going to need to live with clearly, as Route 53 is theirs to manage. But requiring this cross-access, as was shown here in the site plan through here, it's become a sticking point. From the corporate level, there are no objections. Speedway's been spoken with, Dollar General, they're working together, but I think what they're finding is that Speedway's not a very good site, and their parking is right here. In order to put that cross-access easement in, that parking is eliminated. When they lose that parking, they're interested in having shared parking. And at a corporate level, that doesn't seem to work. Having a shared facility with insurance and the way their business models work. So I've been told that that's a sticking point and likely a deal killer. So what I would like to do is respectfully request that the board consider removal of that condition in the approval of the PUD and the variance. And I'm happy to go into the details, the technical details. Some of the reasons I think it's a wish, and we're going to continue to try, but I'm told it's unlikely that they'll get it. But some of the technical reasons, it was stated that people going from the Dollar General, which is down here, remember the alignment, the access will be aligned here, going from Dollar General to Speedway would have to cross 4 lanes of traffic. Technically, the people going from Dollar General to Speedway don't cross any lanes of traffic. They're in the turn lane, they're heading north. That statement is true from people coming from Speedway down to Dollar General, which would maybe be half of it. But they would have access to Zarley here, which is an intersection. So instead of having 4 entrances onto a very busy highway with no control, there's no control in either of these at this time, but this is somewhat protected in the turn lane, heading northbound. Heading southbound, there is access to an intersection here from people who want to go from Speedway down to Dollar General. The other sticky point, I respect the comment about fire and access for emergency vehicles. You'll see that this entrance into, if there was cross-access easement, it goes directly into the pumps. There's no way through the site. The site is congested. When you provide cross-access easement, you're providing them right into the pumps. Can folks sneak through between the pumps and the building? Yeah, they could. But it's not Speedway's a difficult site to provide this cross-access easement to. They lose parking, and as they negotiate, it seems as if they're looking for concessions in the shared parking that Dollar General has instructed me that it could be a deal killer. So worst case for me is that the condition remains. Best case is that it is removed and we can move forward.
Judy?
So I go to Speedway, I go to Dollar General, and I like to be able to go from one area to the next. Just people are going to share your parking no matter what, because if I'm at Dollar General or if I'm at Speedway and I can run over really fast, you're going to want to do that. I can see where you guys might not like that, but people are naturally going to do that. People naturally want to do that. It makes sense to me that this cross area is provided, because I don't like when I go into one spot and I have to get out of the road, come in, go to another spot. I always want to be able to travel along within the shopping area that I'm at, because it's just so much easier, and it is safe, because I don't have to get back out in the traffic and get back into the parking lot. So the holdup is that Dollar General is not interested, and what's the problem?
I think they're both interested, I believe it, and again, I'm not an attorney, I believe it's corporate insurance and the shared use agreement of the parking lot. And I believe they're just hung up.
Well, but I mean, you're never gonna be able to prove where somebody was shopping if something happened. I can't imagine that you could.
No.
I mean, Speedway people could easily come over and shop at Dollar General, and how would you know which was happening? You would never know, so.
Again, I don't know if let's say it's insurance, that was the only word I received, was an insurance issue. Would someone, I'm not an attorney, would someone
Right.
who's had an easement agreement say that Dollar General's policy must now cover folks that are at Speedway? I don't know the answer.
Mr. Pettit, yes.
I'd just like to sort of remind the committee of the situation we're dealing with PUDs. As Kimberly pointed out, they could have proceeded with a long series of variances that would have allowed them to do what they wanted to do, and we would not have had this discussion about the possibility of this cross access. The option was given to them by the board under the provisions of the ordinance to proceed on a PUD approach, which basically says, let's set aside the normal conditions and requirements for development of a site like this and come up with sort of a customized approach. But it needs to be a give and take, and that you'll have opportunities to avoid some of these compliance with variance requirements in exchange for various other things, like whether it was the sign or whatever. That's how this opportunity to talk about a better traffic flow having cross-access was brought up, because they, on their own accord, decided to pursue a PUD as opposed to pursue the variances. It's just a little disconcerting to, after a period of months and months and months of negotiation with this party, where this element about the cross-access was introduced at the beginning of the negotiation, and then they tell us that they're ready to go and proceed, and then at the final hour say, oh, we don't want to do that. It's a rather interesting negotiating posture.
David, do you have a comment?
It was just more specific to if the condition were to remain, and subsequent to that, the agreement could not be reached, how would that be addressed? And what would have to happen is based upon two things. A is that it's a condition of special use that would have been placed upon the special use by the board through a public process, and again by ordinance requirement, where we could consider a major amendment, because it would be a substantial change to the use or actually traffic circulation pattern. It would require that to amend that would require going back through a public process, through a public hearing process by filing another case, just to amend that condition to come to the board for consideration. So basically it required another filing similar to this, just to amend the condition.
Judy?
I know that we're looking at PUDs for many of the things so that we do create situations that are much better for the entire area, not just specific for one business entity than another. That's the way we've been moving towards, right, Kurt? We're not.
Well, we've had recent discussions about this
Right.
on the kind of truck stop, multi-type of, and this is not directly analogous to that, but it gave us an opportunity to once again remind ourselves of what a PUD is and how it's an optional approach that allows you not to adhere to the strict requirements of the zoning code, but sort of customize the situation that's in the interest of not only the developer, but all parties.
Right, which I think makes a lot of sense, and I think that both parties should be wanting to do that because it benefits both parties, so thank you.
Steve, do you have a comment?
Thank you, Mr. Chairman. Just to tell you a little bit about how this case worked out in the department. Kimberly handled the majority of the case. I handled the cross-access part. And that was due to a couple of significant reasons. One, I have significant involvement with the intermodal facilities. Two, I was the project manager on the Illinois Route 53 plan. Three, Colin Newsom, who is underneath me, is currently working on the Preston Heights-Patterson Road plan. A couple of things. First of all, I'm going to recite from our ordinance regarding cross-access requirements. Vehicle and or pedestrian access between abutting parcels may be required in accordance with all applicable county requirements. In this case, the applicable county requirement is a special use permit for a PUD, a planned unit development. I don't have to describe the give and take of a PUD, but as you know, we relax standards in conjunction for a better development. In asking for this cross-access easement, I have spoke both to Dollar General, the previous person that was involved by email, and I spoke on the phone to Speedway. What it sounds like I'm hearing is that Dollar General doesn't want to go a little bit above and beyond what they should be required to do to ensure this cross-access on the adjacent property, the Speedway property. Why this is important is because we have left turn movements. To go out of Speedway and to come into Dollar General, you're going to have to make a left turn. With two driveways about 50 or 60 feet apart, you know as well as I do, we're all going to go the wrong way down that road. We didn't force Dollar General to do a full-blown traffic study because I could pretty much recite that chapter and verse. In front of that store, there's approximately 7,000 vehicles per day. Speed limit is 45 miles an hour. Every fourth vehicle is a tractor trailer. Under those conditions, I couldn't see a better opportunity to incorporate cross-access on these two parcels that would help safety in such a dramatic manner. I mean, it's almost a given, a natural. And I really understand this community needs a store like this. It's going to be a great thing, but sacrificing safety where we have kids trying to cross streets, where we have mothers making left turns, it's something you really need to consider. So thank you.
Bob?
I'm sure on the developers, their issue with this whole thing is when they go reciprocal parking, that if Speedway were to sell or Dollar General were to sell, I'm sure that somehow that would continue on because there's a prime example of that on Harlem where the Portillo's is and the Krispy Kreme used to be. They have reciprocal parking and that follows. Whoever buys that actually vice versa. So that was something that they had. I'm sure the attorneys are that's their concern. So, but at the same time, I mean, if they could alleviate a problem, and I'm sure they would only lose 2 spots.
I don't know how many spots would Speedway lose?
Yeah.
If we can go to that site plan slide of line control, it's a little deceiving. There are 4 spaces marked here. You would lose 3 of the 4. But if you look at this last one, that's where folks are coming right in around the sign. So that's, while there's a lined area, if you look in the aerial, there really aren't more than about 3 parking spots. There's probably room for more to come out and park here, but you're getting folks that are coming right around and you're out into the ground. Again, remember, it's hard to, the pumps are right there. So this is leading you right into the pumps. And they would lose these spots. So I think what Speedway is thinking is they're losing all.
Any other comments, Becky? Mr. Pat?
Certainly don't want to be overly argumentative here, but just want to reinforce the point here about what's a PUD and what are variances. I know the board to be absolutely pro-development. You've made that very, very clear over and over again, and I know you would want to be so in this instance. The issue here is not one of making it difficult for a developer to move forward. The point is, they could have gone forward with those variances and sought and obtained approval for all those variances and done exactly the way they wanted to do it, assuming the variances were approved, without this becoming an issue. But because they wanted to go the PUD approach, there now are some important safety considerations that we might not have been able to obtain if they had merely followed the approach of trying to obtain the variances. So I think the important thing that you need to weigh and balance is that what is it really going to be equally balanced? There's the desire to have the development. We could have the development just by having them pursue the variances and having the board approve the variances. Those that needed board approval, many of them might have been approved at the level of planning and zoning. But if we are going to go to the PUD, is there sufficient, the old phrase, quid pro quo, this for that? We know what the this is that they want. The question is, are we getting the that in the way of safety in exchange for relaxing on a relatively small, compact site relaxing our normal development standards to have the benefits of this residential, I beg your pardon, this commercial service. So I just want to be sure you realize this isn't a pro-development or anti-development type of approach. Either following the variances, you could have the development. But following PUD, you could have the development. But do you want to have it be a better development with PUD out of a negotiated process that appeared to be going fine until the 11th hour?
So I really think that Dollar General needs to get to work with the Speedway, because we have a PUD, we've decided we want to use PUDs because it makes more sense for us. Our planners can make a better fit and safety issues and everything else by allowing you guys not to have to follow variances with special use permit. So you went PUD, so now you go PUD, now you get this list of only 5 things that you have to comply with. But now you want to say, well, we really don't want to do cross-access. I think cross-access is important. I think it should be there. And if you guys can't work it out amongst yourselves, you all have plenty of money. Dollar General has plenty of money. Speedway has plenty of money. You should make a really good, we have intergovernmental agreements all the time with various different groups, entities, because we want to make it a better fit. This is the best fit. Our staff has done intensive work on it. It makes sense to do it. I don't see how we can do it without that cross-access. That's how I feel.
Denise?
Brandon, thank you for being here, and I appreciate your efforts on behalf of this development. And as I said before, I do want to see this be established here. I'm familiar with that area, and I know that a lot of people will walk to the Dollar General from that Preston High subdivision. We will probably get kids walking down from Sugar Creek, which is immediately north of there. There is the traffic issue on Chicago Street. It has been for a long time and continues to be and gets worse. So while I do want to see you come there, I want to see the cross-access. That's really important. And you need to have that piece. So I would encourage you to spur whoever you can to continue to work on that piece.
Okay, yeah, again, to summarize, my understanding is if that condition remains, then this is done. But if that is the condition, then we'll pass it along, and I tell them to continue to try. But
Thank you.
that's what it is left. Thank you for your time.
Thank you. Are there any objectors to this proposal? No objectors. We have a motion to approve map amendment from R6 to C3. Good motion. Second?
Second.
All in favor, say aye.
Aye.
Opposed, motion carries. Special use permit for PUD. Motion.
Second.
Second. All in favor, say aye.
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 Any opposed? Motion carries. Okay, other business, on Baxter subdivision.
Hi, I'm Nicole Radel. I'm here on behalf of Jim Song for the Baxter subdivision. It is a minor subdivision in Green Garden Township. The purpose of the request is to create 2 single-family residential lots on a 5-acre parcel.
Any questions by committee? Any objectors to this? We have a motion to approve.
Second.
Motion second. All in favor say aye.
Aye.
Any opposed? Motion carries. Other business, Elder Cottage. David?
Yes, if you recall, at the committee's direction, we prepared draft text amendment language to, in summary, modify the Elder Cottage housing opportunity requirements in the ordinance to basically go back and revert to the way they were prior to 2012. That was done. The committee directed us to a public hearing. We did at the commission, and at the commission there were no public comments on the matter, and so it's now back before you to have any further comments you may have, transmitted to the board for their consideration.
Any questions by committee? Judy?
So I just wanted to know what, I'm not really sure, what type of advertisement is done so that people are aware that we want to make a text amendment to, for this echo housing?
Okay, the typical process for any text amendment is, number one, is publication within the newspaper media within one county. Typically, at minimum, it's one of general circulation. It's also posted on our website with the text available for review as well, with the agenda packet. And typically, this is all done a minimum of 15 days prior to the public hearing.
Okay, so I think I remember you guys saying that we have like 18 existing eco housing developments in Will County. Do we have that?
It's approximately 18 countywide. Yes.
Okay. And of those 18, how many were approved as a right as it is now? Or how many came into existing as a right as it is now versus when it was before as a special use?
I don't have the exact number, but I believe it's at most possibly 2 to 3.
Okay. And then the additional cost, if it's a special use permit, would be how much money total?
The fee for the zoning is $675. There are other costs that are associated with it, where the applicant pays newspaper publication fees, and any other costs that may be associated with it, such as certified mailings, and any other fees they may pay for counsel if they obtain counsel.
And you don't have any type of estimate, because it could vary depending on how many certified mailings you have for who's existing around,
That's
right?
correct.
So maximum of additional $1,000 might seem.
Not including if they don't obtain
Attorney
counsel, attorney fees, I suggest that they, thousands probably the top end.
Right. Okay, thank you.
Bob, you have a comment?
Yes, explain the benefit to our change. Why are we changing this? What is going to be the benefit of this? Oh, this change.
Well, this was the direction of the board and the committee to revert back to the special use process, and primarily to put it back into, again, the public process for notification purposes.
Okay, so basically all we're doing is increasing the cost of someone applying for one of these.
Well, there are costs associated with the process, yes.
Okay. Again, I know it's very few that actually utilize this, but I think we have to be careful with this, because all we're doing is adding additional expense, in my mind. And, you know, the process that we had before, I think, you know, that $675 or whatever it's going to cost, $1,000, I'm sure that somebody would probably engage an attorney, that type of thing like that. So, I mean, it's quite a substantial cost, and I think it just adds another barrier, you know, as far as promoting this type of benefit. So that's my personal opinion on it. So I would say leave well enough alone, you know, at this point in time.
I think the reason that it was brought back was some county board members have been contacted about a potential site, and that the residents didn't have a voice in it. They couldn't object to it because it's something by right. But if you have a special use permit, then people can come and object and give their opinion. So I think that's the reason why it was brought back. Judy?
Right, so I was just wondering, I know that was one situation, so that one situation, had those people filed right now?
Yes, they have.
And will they be able to get this eco housing right now?
They have filed for the building permit for the eco housing under the terms and conditions of the existing ordinance. So assuming that they have received the building permit already, but there will be the process of inspections and so on and so forth, ultimately leading to occupancy. So I think this may be the sense of your question, that in the particular situation that gave rise to reconsideration of the current provisions, the timing is such that in that one particular situation, the echo unit is going to be there. Now, if we were to make this change, it will affect situations going forward. But of course, you know, one could say, well, that's what you do. You live and learn. You know, in this particular situation, since it was a by right use and surrounding neighbors weren't informed and they feel like they should have had an opportunity, maybe the feeling is that, well, we should have learned from this situation and in the future return it to special use so that we can be assured that surrounding neighbors will be notified. But if it wasn't obvious, I just want to make it clear, staff is not in an advocacy role here. We are utterly indifferent on this point. We just know that board members brought it up. They asked us to simply bring it before you of what it would take to change it. We're not really recommending pro or con the virtues of keeping it either the way it is right now or going to special use. We were just asked to place it on the agenda for your consideration and deliberation.
Right. So in the past, we used to have it for special use permit. Then we found out that the majority of the cases, the vast majority, what percentage was it that always got approved?
Oh, it was upwards of 99%.
So we 99% of the time we approved it. So then we went to say, well, it's right in this zoning, if your home is zoned, if your property is zoned this way, then it's just a right of use of your property. So I think that while we only have 18 in the county, for those 18, it's very important to have. And I don't think that an additional cost to anybody makes sense, because I know that if it had worked for me in my situation with my my older relatives, it didn't work out that they could live with me on the property. But I would have loved to have been able to do it if they physically were able to, because it's so nice to have your family member there, then they have to spend upwards of $200 a day, or put them in assisted living where they go and they're with people that they don't know, and then you as a relative have to travel there. So for me, I don't like the additional costs. This is one issue. One thing I cannot stand is when government puts in a barrier for property owners for one person, one issue. So I'm not going to be in favor of this. Thanks.
And again, I don't want staff to think that we're actually saying that you are setting the policy or advocating one way or another. We understand. You do a great job for what you do. But again, this is a very touchy subject for me. And if you take that and you increase that cost, let's say it's rounded off to $1,000 and the whole process is $10,000, basically what we're saying is Will County wants 10% of this. So I think that this is a very treacherous slope right now, what we're doing here. I think it's extending our reach of government into these people's lives. And I say that because the safety is protected now, they still have to go through the process of inspections. You guys are monitoring what they're doing out there to make sure everything is done correctly, properly, and in the best interest of the residents. I don't think that we actually should throw up any additional roadblocks on it, and I will not support this change. Thank you.
Any other comments? Steve?
It seems like the only difference, other than the cost, is that the neighbors get a chance to voice their opinion. So when we redo this, why can't we just leave it alone and say that we're going to let the neighbors have a chance to voice their opinions on what they're doing? In other words, make us aware of what's happening, and if there is a problem, then we can address that problem. But I mean, it's not we're saying it's a right to have it right now, right? Correct?
That's just a term. What it's saying is that if you are in a certain zoning category, there are certain kinds of uses that are allowed without receiving additional board approval.
Right. Well,
currently, this is one of them. And if it's that kind of situation where the use that you're doing has been approved for that zoning category, then you're not required to notify the county unless you're for the purpose of a building permit, and you're not required to go through a zoning process where you would notify the neighbors. So I guess to your goal of how do we give the citizens an opportunity to comment, the difficulty here is that if it's in the kind of situation it is now where it's an allowed use, the only interaction with the government that they have is when they go to get the building permit. And under building permits, that we don't, require people to notify their neighbors that they're seeking a building permit or put a notice in the paper that they're seeking a building permit. That's only done when it's something that's required under the zoning ordinance. Mr. Balish, I guess I would add on to what you had said, that the additional element of an SUP, beyond just the fact that you notify the neighbors, as you know, with an SUP, you can add conditions. And one of the good things about an SUP is it allows you to look at the site-specific situation. And if there were some unique element about where it stood in relationship to neighboring properties or some other element, you're able to put in a condition that has to mitigate that, perhaps with enhanced screening or something else of that nature. That's something else that an SUP approach would allow you to do. So I just want to be sure people were aware of that. Again, not advocating one way or another. I'm just simply saying that if it's a special use permit, one, yes, neighbors get notified, but it also gives the board an opportunity to impose conditions, additional conditions to mitigate any impact on the neighbors that just simple adherence to the zoning code might not require.
See, my concern is that I don't like the addition of fees, and it just increases the size of government, which I don't like. But at the same time, with an eco home, I live in a neighborhood just like Chicago Lex. Well, what if I decided that I want to put a trailer as big as my house, because I don't have a big house, in my backyard? Well, maybe my neighbors wouldn't care, maybe they would care, I don't know. But, you know, but that really wouldn't fit.
Okay. Well, let me be clear that by the so-called by right, and that's just a phrase, which means a use that's allowable within that zoning category, there still are setback requirements. There are still setback requirements, which might constrain the ability to put in kind of the scenario you were painting of a huge trailer that was completely disproportionate to the size of the yard. That wouldn't work under existing conditions because there's still setback requirements.
You know, with your clarification of that, you know, I would just leave it alone too. I'd be with Judy and Bob.
Yeah, so another thing too though, Kurt, to qualify for eco housing, there's a list of things that they must follow. Could you please go over?
Yeah, there's two basic conditions. You have to be, one of the residents in this situation has to be either 65 years old or, am I correct, 65, or disabled. There's been sometimes a misunderstanding that you have to be 65 and disabled. That is not the wording after consultation with the state's attorney's office on repeated occasions. The interpretation of the ordinance is that you are 65 or disabled.
It's 62, isn't it?
Is it 62? Beg your pardon, 62 or disabled.
Right, and so, and how often do they have to verify
Once
that?
a year.
Once a year. So they have to verify once a year. So you have the setback, so like in your neighborhood, they wouldn't be able because there's no room. But out in the rural area, there, in the larger properties, there would. So, okay, thank you, Drew.
David has another clarifying point that I think speaks to some of Mr. Balash's concerns, if he could make that comment first.
The special use, as proposed and where it is right now currently is a permit, it only goes to R3 zoning. It does not go in more dense districts of R4, 5, and 6.
Yeah, just on that, there's some verbiage in there though that's kind of interesting to me. It basically said that you have to meet the criteria, you know, relative, et cetera, et cetera. But there's also said that if the person living on the property that owns the property is a caregiver, was a licensed caregiver or whatever, then does that mean that, what's that? No, there's something at the end there. It'd take me forever to scroll back to it, but.
Well, David will find it, but going from memory, when it uses the term caregiver, happy to be proved wrong, but I don't believe that it's talking about a licensed caregiver. It's talking like, you know, an adult child who is performing caregiving tasks. You don't have to be a licensed caregiver.
Can you read that section to me?
Yeah, it's the owner of the principal residence and the resident of the eco unit must be related by blood, marriage, civil union, or adoption, or be a licensed caretaker.
A licensed caretaker. So licensed caretaker, technically they can move in if their neighbor had somebody that was in need, then technically that should be, there's a glitch in there that they could actually, if they're a licensed caregiver, you could actually put an eco housing on your property. Am I reading that incorrectly, Mr. State's Attorney?
Okay, I read it now. Could you answer your question one more time?
So technically, if my neighbor, I'm a licensed caretaker, if my neighbor had someone that was in need of eco housing, I could actually put a eco housing compliant unit on my property because I'm a licensed caretaker.
Technically, that sounds accurate.
All right. I don't know if that's something that needs to be fixed, but it's an interesting.
Well, if the committee felt it appropriate, you could remove it today and move it forward. And just to note, we have not, in my knowledge of almost 20 years in the county, have never experienced an issue with that, but if there's a comfort level by removing it.
Well, I don't know. I don't know what the ramifications of removing it. Maybe there's somebody that actually would need that situation. I don't know.
To me, it's possible that, you know, you might have somebody in your family who has a need, and I happen to live on the home, and I'm currently the caregiver, and I would agree to have the eco housing on my property, so that way they're right there by me. You're not able to do that because you're working whatever hours you're working, your wife is working,
Yeah.
in which case I would then be home 24 hours a day possibly, so you might want to make an arrangement with me for that to happen, and this would facilitate that.
Okay, all right. I have no problem with it. I just want to know if that interpretation was correct.
Okay, if there's no other discussion, let's vote this up or down. If we vote it down, David, does it go to the county board or not, or does it stay here?
No, it would still go to the board for consideration, but
Okay.
with the committee's recommendation.
Okay, well, let's have a motion to approve, and then we'll vote it up or down. Motion by Judy, second by Laura. Roll call, please.
Denise Winfrey,
Yes.
Judy O'Gara,
No.
Robert Howard,
No.
Steve Ballage,
No.
Lauren Staley Perry,
No.
Chairman White.
No. Okay, motion is voted down. That goes to county board with a no vote recommendation. Next item on the agenda is the non-conforming lots. David, do you have anything on that?
The current update is basically we're working with our GIS department to try to quantify the number of parcels that we would try to be addressing. And we need to be very careful about doing this. It's a very important topic, but we have to be very careful because unlike the situation like with the echo units where we have a finite number of parcels we're dealing with, once we go down the road of declaring certain parcels within the county as legally non-conforming, you can't really go back on that. So we're trying to work with them to quantify both the number of parcels that by district that are deficient in lot frontage and lot areas. So again, we kind of have a number of what we're dealing with, perhaps geographical areas and things of that nature, so that we can really make informed decisions that we want to proceed. So right now, again, we're in conversations with our GIS department to try to work with ArcGIS to query and get the numbers.
Okay, so it's still something in process?
Yes.
Okay. We'll move on the agenda for comments. I have no comments. Committee members, any comments? Director, any comments?
Mr. Lazarek has something
Steve?
he'd like to share with you.
Thank you. Oh, I'm sorry, thank you. Real quickly, at our next PZC meeting in September, in addition to a small to moderate caseload, we're also going to be having a workshop meeting where we're going to have some members from CMAP, the Chicago Metropolitan Agency for Planning, coming out and talking about their On-to 2050 plan. That's their regional plan. And I wanted to invite all of you, but I don't know the protocol following the Open Meetings Act. So if you are interested in going, I think you might want to talk with your county board liaison and make sure. And that is the first Tuesday in September.
At 6:30?
At 6:30,
Right
correct.
here in this room?
In this room,
Okay.
and it's going to follow the zoning cases. So I would think if you got there around 7-ish, you'd probably be fine.
Okay.
Thank you.
Okay. Any public comment? A motion to adjourn? Motion, second. All in favor say aye.
Aye.
Adjourn, thank you.